Hello students, after introducing you about the sixth schedule, let's take up another topic, that is powers under sixth schedule of the constitution which have been given to the autonomous district councils, which are established in the tribal areas of the four states, namely Assam, Meghalaya, Mizoram and Tripura. The governor of these four states, that is Assam, Meghalaya, Tripura, Mizoram, are empowered to declare some tribal dominated districts or areas of these states as autonomous districts and autonomous regions by the executive order as per the provisions of the sixth schedule we already discussed. No separate legislation is required for this purpose. The governor of the state concerned is also empowered or has the power to include any other area, exclude any area, increase or decrease, diminish united districts or the regions, as the case may be, and alter the names and boundaries of these autonomous districts or the regions. In other words, we can say the governor by the executive order can make necessary changes so that the areas under the autonomous districts or the autonomous regions may be diminished, may be changed, may be altered, may be increased or may be decreased. In other words, we can say executive powers relating to the administration of the autonomous districts or the autonomous regions are vested in the office of the governor. How these districts or how these district councils or the regional councils in the autonomous districts have been established. As you know and already discussed, that Article 244 and Article 275 provides for the establishment of the district councils or the regional councils, as the case may be. Each district or regional councils is an administrative unit which is authorized to administer the areas under its jurisdictions. These units are named as district council according to the names of the area or the districts, and regions as per the name of the regions. These two bodies continue to function unless otherwise repealed by the governor of the state. I would like to emphasize this here. Once created, they will continue to function till those are repealed, no doubt by the governor. Further, these autonomous councils or autonomous region, they enjoy legal status along with the constitutional patronage provided under Schedule 6 of the Constitution. There are certain powers which are assigned to these autonomous district councils. Autonomous district councils and regional councils to make laws. District councils or the regional councils are endowed with the power to make laws with respect to the allotment or use or setting apart of land which is not under reserved forests and meant for agriculture or grazing or for residential or for non-agriculture purpose. However, the type of land stated above may be acquired by the state, obviously as per the law enacted by the parliament or the state legislature in this regard. The council can also frame laws to manage forests other than reserved forest, to manage canal irrigation, to regulate the zoom cultivation or the shifting cultivation. It can also make laws relating to the establishment of village or town committees or councils and their powers, matters relating to village or town police and public health and sanitation, etc. the appointment of succession of chiefs or the headsmen, the inheritance of property, marriage and divorce, and social custom, etc., are the other areas where these councils can frame the laws. The laws passed by the autonomous district councils come into effect only after the assent of the governor of the state concerned. There are certain restrictions on the laws passed by the autonomous district councils or the regional councils in the matters to make laws, and that restrictions is imposed that the consent of the governor is mandatory for that purpose. The laws made by the state legislature on any subject that comes within the jurisdictions of the autonomous district council would not extend within the jurisdictions of the council unless the respective council so declare by public notification. The president in this regard to a central act and the governor in this regard to a state act may direct that the central act or the state act shall apply to an autonomous district councils or shall not, or with such modification as may be specified. After deliberating on the legislative jurisdictions of the autonomous district council, let's talk about the powers relating to the administration of justice. Administration of justice of the regional councils and the district councils. These bodies are empowered to discharge judicial functions, including the judicial power for the trial of offences committed by the members of the scheduled tribes in their respective territorial jurisdictions. The judicial administration is two-tiered one, that is at the village level and the district level. The village council, here the case is if both the parties are scheduled tribes, and the district councils act as the court of appeal. It is worth to state here that except Tripura, tribal areas, autonomous district councils in Tripura, Borderland Territorial Council in Assam, all other autonomous district councils have been given judicial power to deal with certain types of civil and criminal cases, mostly according to their respective customary laws. The councils have been empowered with various judicial powers relating to civil and criminal matters such as establishment of village courts, etc., which mostly operate as per the customary laws prevalent in these areas. The High Court of the state concerned has the power to look into the issue of jurisdiction and decision of such courts. The district councils have also the power to establish primary school in their jurisdictions. They have also the power to establish dispensaries and other facilities. The district councils in autonomous districts are also assigned with the powers to establish, construct or manage primary schools, dispensaries, markets, cattle ponds, fisheries, ferries, road and transport, and waterways. These councils are also entrusted with the responsibilities to regulate, control, and manage all such facilities, including the decisions to decide the language to be used in imparting education at primary school level. These councils have also been assigned with the power of assessment and taxations. These bodies have the power to assess and collect land revenue, however, in accordance with the principle laid down by the state government in this regard. Here I would like to clarify, the state government can lay down certain guidelines to impose such taxes, and the autonomous district councils or the regional councils have to abide by those guidelines while imposing such taxes. The tax on land and buildings and toll tax on the residents are also under the scope of these councils, and these councils have the power to collect taxes within their jurisdictions. These councils have been endowed with the requisite authority to do so. They can issue licenses and they can lease out for prospecting and extractions of minerals and entitled to get royalties accruing to state from mineral extractions. Besides this, these councils are also endowed with the powers to regulate money lending and trading by non-tribals. They have the powers to regulate money lending and trading by non-residents or non-tribal people living in the area under their jurisdictions. Thus, many kinds of powers and responsibilities have been assigned to these councils, and funds are also required for discharging all these activities which are assigned to them. Hence, the district fund and the regional fund are also established for respective bodies or respective councils, and the rules for operating and managing these funds and other financial matters are framed by the governor of the state in this regard. The sixth schedule provides the framework of the autonomous and decentralized governance with legislative and executive powers over subjects like water, soil, land, minor forest resources, local customs and culture. The autonomous district councils established under the sixth schedules of the Constitution have also been given special powers which may be compared and contradicted with that given to the local self-government institutions in rural and urban areas under the 73rd and the 74th Constitutional Amendment Acts respectively. The experts in the field as well as the champions of democratic decentralization are of the opinion that autonomy granted to the tribal communities led to a sense of responsibility and political settlement within the tribal societies. The local people are able to maintain their customs, traditions, and age-old practices, particularly relating to the conflict resolution under customary laws. Again, they are free from the influence of the so-called modernity, which is aligned to their cultures and the existence. So, this talk has made you to realize that there are many kinds of the powers relating to the local affairs, relating to the management of affairs of their own society, or the local matters relating to local matters, including the judicial one. They also have the legislative powers, particularly in adopting a law which is relating to their local life or which is relating to their social life. And those are no doubt better than the local self-government, or you can say that has been providing more autonomy, more independence in comparison to the local self-government established under the new constitutional amendment, that is 73rd and 74th one. And that's why these councils are different from other institutions established, and those are more democratic one and more participative one in comparison to the other institution established in the country. Thank you very much for paying attention to this talk. In the next talk, we will discuss about the structure of the district autonomous councils or the regional councils which have been established in the 4 states of the northeastern region of the country. Thank you very much. Thanks again.